brokerage and compliance resources, and we work with your office in that capacity. So we're available to ask questions, talk about issues, whatever you might want to talk about that is real estate or contract related or anything else. I'm happy to talk with you. And today we are doing a class on the standard contract. And the last time I did kind of like a marathon class with the listing agreement and the as-is contract. So we've gone through all of those fill in the blank parts of the as-is. And in most cases, the standard contract is the same. So today, I think it makes sense to just focus on the differences, right? Because if you understand the as-is, you're going to understand the standard. You just need some maybe additional attention to where the differences are. So that's what we're talking about today. And I'm going to share my screen as I go through. I may not be able to I won't be able to pay attention to the chat. I'll just tell you that. So if you have questions as we go through, stop me and let's talk about it. And then hopefully I can finish within the time, and we might have a little bit of time at the end for other questions. Does that sound good? Awesome. Okay. So I'm going to share my screen. As I said, this is the standard contract. Everyone sees it?
No.
Yep, I see it.
You see it?
Yep.
Okay. So I'm going to scroll through, and I'm only going to comment on where the differences are. Okay. So as I scroll through, if there's anything that catches your eye and you have a question about it in general, just stop me and we'll talk about it. Otherwise, like I said, we're just going to focus on the differences between the standard and the as-is. And I also have the as-is contract on standby so that I can help to illustrate where those differences are. So you can see one and then the other. Does that make sense?
Yeah.
All right. So scrolling through, everything's the same. Everything's the same. Financing is the same. And here we come to our first difference at paragraph 9. Now, I'm going to show you the as-is contract briefly, just so that you can really clearly see where the difference is. All right. So you see here in paragraph 9A, beginning at line 127, and we're talking about all the closing costs to be paid by the seller. Okay. And then line 131 is our last line of fill in the blank stuff, right? Because it says municipal lien search, and then on the second column it says other. And then we go into seller's continuing maintenance obligation under paragraph 11, that we may escrow some funds to take care of that, all that kind of stuff. Now let's look at the difference. Here's our standard. Okay, right here at line 135 we have language that is not in the other contract. And we have 3 categories of expenses that the seller could potentially be liable for. And you'll see that in each instance, we can either fill in an amount or a percentage of the purchase price. And the default percentage is 1.5%. So imagine 1.5% of a $200,000 house and 1.5% in each of these categories. It's going to add up pretty quickly, right? And suddenly the seller is obligated to spend up to 4.5% of the purchase price. So our first category at line 136 is general repair items. And we'll talk in detail about that when we get to paragraph 12. And so always when you see a term that is in parentheses and in quotes, that means it's a defined term. So under the contract, we're always going to follow whatever that definition is. And sometimes the definition may not be our common sense everyday understanding of what those words mean. Doesn't matter. We will always follow what the contract says is the definition. So general repair limit is a defined term, and it refers to that amount that you have put in the blanks at line 136. Okay. Now the next one is line 138, And this has to do with WDO treatment and repairs, WDO, wood destroying organisms. And again, we have a defined term of WDO repair limit. Defined term, it's going to be important when we talk about paragraph 12. Then our third category is permit items. It says, and this is important, closing out open or expired permits and obtaining required permits for anything that was not permitted. So that could be pretty expensive, right? That's pretty comprehensive if we have to address all those permit items. And then we have a defined term, the permit limit. Okay, does that make sense to everyone?
Yes.
All right. Before we go further, here's something to consider. The conversation you have with a buyer or a seller about the form of contract to use. And I think I've provided some of these scripts to you before. I'll try to remember at the end to put it into the chat so that everyone can download it. So the choice of contract is really something that should be done on a case-by-case basis. And I used to hear a lot of agents say, I always use the as is, or I always use the standard. Well, guess what? If you always make that choice, then you may not serve the best interests of your clients and customers, because it really is up to what their goals and objectives are for the transaction. And that may change from one moment to the next, right? Have you ever had a buyer or a seller change their mind? Yeah, happens all the time, right? So that's why you need to have these conversations with the buyer and or the seller, depending on who you're working with. And one of the important conversations to have with the seller is, and this should happen at your listing appointment, and I know there's a lot going on there, so maybe a separate appointment just to talk about the contracts, but you want them to see the contracts way ahead of time before they get an offer. And just point the seller to this provision beginning at line 136 and say, if you get an offer on a standard contract, it could potentially require you to pay these amounts for these items. Are you comfortable with that? And they'll go, oh my gosh, no, I can't afford to pay anything. I've got to get out of this house because I can't afford it. Good to know, right? So then you can guide them that if they get an offer on a standard contract, you could say, well, maybe we want to counter to have an as-is contract, or maybe we just want to put that in the comments on MLS, as-is contract only. All those kinds of things, right? That's part of the preparation. So have those kinds of conversations with people. You would also have another conversation with them when we get to paragraph 12, and you're going to have those kinds of conversations with the buyer as well. So we'll hold those till we get there. Is that okay? All right, any questions about paragraph 9 before we move on? We're going to refer back to it when we talk about paragraph 12. But the important thing is we have those 3 categories of repairs, and we have the limits up to which the seller is going to be obligated to take care of all those costs. All right, moving on. Now, here's the difference between the standard and the as-is, and this is paragraph 10. Last week on the forum, I did the class 10 for 10 disclosures in paragraph 10. And we're at paragraph J at line 252, seller's disclosure. So the first line should be very familiar to everyone. This is Johnson v. Davis, right? No facts materially affecting the value of the property that are not readily observable and which have not been disclosed, right? And then we go on and it says, except as the seller may have disclosed, we don't have any violations of building, environmental, or safety codes. Okay, so remember what that looks like. Now let's look at paragraph 10 in the as-is contract at J. It's different, right? There's more stuff in there. there's another sentence, and it starts at line 239. It says, except as provided in the preceding sentence, and the preceding sentence was Johnson v. Davis, right? Everybody should just have that. You should be able to say that. If somebody wakes you up in the middle of the night, it says Johnson v. Davis, you should be able to say that language, because we have that same duty. And we need to remember that for ourselves. We need to be able to advise sellers and buyers about that as well. So except for Johnson v. Davis, seller extends and intends no warranty and makes no representation of any type, either express or implied, as to the condition of the property. That's the as is part, right? No reps and warranties. It is as it is. And a lot of people mistake the as is nature and think that that also means no disclosure. No, clearly at line 238, there is the disclosure requirement. As is just means as is. I still have to tell you what might be wrong with the property, right? So as is different from Johnson v. Davis duty to disclose. A lot of people mistake that. All right, now let's stay here while we're here. Let's take a quick look at paragraph 12. It says property inspection right to cancel. Remember that, property inspection right to cancel. And at paragraph A, we talk about the inspection period. And it says that buyer, it's 251, buyer's sole discretion, buyer can terminate. So we talked about this before, right? That means any reason, no reason at all. Grandma doesn't like the color of the house across the street. Okay, we're going to terminate. The buyer can do that. They have the absolute sole discretion to terminate. Now, let's look at the standard contract, and you'll see it's different. Remember, that one was right to inspect and cancel. This is property inspection and repair. Different, right? No cancel, repair. And here's what it says. Buyer shall have, within the inspection period, right, the right to have what inspections they want to have. It's not mandatory, it's permissive. Buyer may have inspections done. Buyer is not required to have inspections done. And these are the type of inspections. General, remember we had that as a defined term, WDO, and permit. And we're going to talk about each of those below. This is the kicker though. If buyer fails to timely deliver the notice that is required below, which we're going to talk about, then buyer waives the right to have the seller make any of those repairs. So super critical date to track if you're using the standard contract. You want to keep track of all those dates, make sure the buyer sends the notice that is required with regard to all of those items, the general, the WDO, and the permit. So any questions about that? All right. Oh, hold on just 1 second. Okay. Yeah. Our first category here is the general property inspection and repair. So we talked about the general repair limit in paragraph 9A. So this is the limit that applies in this paragraph. Okay. So it says that seller is obligated to make all of those repairs, and there's another defined term, general repair items, that are going to show up in the general inspection. Remember, every time we have those parentheses in the quotes, it's a defined term. Here's another difference. By a person who specializes in and holds an occupational license, if it's required, to conduct home inspections, or who holds a Florida license to repair those items. Okay. So we either get a licensed inspector to come out, or we get a licensed person to come out and inspect what they're inspecting, right? So if you want to have an inspection done on the air conditioning, then you either get your general licensed inspector or you get somebody who's licensed to do air conditioning repair and maintenance, right? They have to be licensed. Same with the plumbing, same with the electricity, same with everything. They have to be the licensed inspector or they have to be licensed to do that work. So here's the script for you. G, my brother-in-law, Bob, is a licensed plumber in Missouri, and he's going to come down and visit. Can he do the inspection on the house? No, because he's not licensed in Florida, right? So he can't do it. Now let's look at this one in the as is. Okay, it just says that buyer can have inspections done. It doesn't specify that the inspections need to be done by licensed people. Mostly they are, right? But if I want my brother-in-law Bob to do the inspections while he's here, if it's the as-is contract, that's okay. I could even have grandma do it. If she's always wanted to do home inspection and she's always wanted to do plumbing and air conditioning and all the rest, she can do it, right? Under the as-is contract, not so much in the standard. So that's the conversation you have with people. If the buyer says, my brother-in-law Bob is an inspector in Missouri, and when he comes to visit, he's going to inspect the house. You go, okay, then you want to use the as-is contract, because otherwise that's not going to work. Make sense? On the other hand, let's say Bob lives in Florida, he's licensed in Florida as a plumber. He can come inspect the plumbing, but he can't inspect the roof or the electricity, like the breaker box or any of that stuff. He can only inspect what he is licensed to do. Everybody get that? That's the script that you have, as you're talking with the seller. Look, the buyer is going to have licensed people come and do all these inspections. Okay, cool. Doesn't affect the seller so much. The buyer, though, it could affect them. Hey, my best friend is really good at this, but he's not licensed. Okay, then you can't use him if you're using the standard contract. So, and those conversations do happen in the course of the transaction as you're helping buyers look at houses and all that kind of stuff. So that's a script to keep in mind. All right, so here's our first category, the general property inspection and repair. So we're going to specify which items the seller is obligated to repair, and these are called the general repair items. And it says that some categories of things are going to be covered and some categories of things are not going to be covered, right? It has to fit within that general repair item definition. And this part is heavy on definitions. That's why I keep saying, it's in parentheses and it's in quotes, because heavy on the definitions, because this is where your negotiation is going to come in on the standard contract. And we'll see that in just a moment. So the buyer has the inspection done within the inspection period, right? And then the buyer needs to give notice to the seller of any of those items that need to be repaired. And here's the standard. Oh, let me tell you the time period though first, right? So they have to do that within the inspection period. And then we trigger a time period from the seller, and that's 10 days. So imagine if we default to the 15-day inspection period, and now the seller has 10 days to respond to the buyer's notice. We're 25 days in. So if you're using the standard contract, make sure you put the closing date out far enough to accommodate all the stuff that needs to happen here. All right, does that make sense? So here's the property condition. Here's what we're looking for. All of these items must be free from leaks, water damage, structural damage. So ceiling, roof, fascia, soffits, exterior, interior walls, doors, windows, foundation. And then all of that, plus the pool equipment, non-leased major appliances. So sometimes people lease high-end appliances. If it's leased, we don't care. We're only looking at what they own. Heating, cooling, mechanical, electrical, security, on and on. You can read it. And we have to maintain it in working condition. So working condition is, guess what? A defined term, right? And we'll get to it in a minute. Next thing, torn screens, fogged windows, missing roof tiles or shingles have to be repaired or replaced. So that's important, right? Then it says seller is not required to take care of cosmetic conditions unless it's because of a defect. So here's an example. My husband did this. Years ago, we're still in Kansas City. He made some kind of a smoothie drink, you know, and forgot about it. And he put it in a bottle and the bottle stayed out and it fermented. And he opened up the cap and it exploded all over the kitchen ceiling, right? So blueberry stains on the kitchen ceiling. That's cosmetic. It's not a stain that came from a leak in the roof. It's a stain that came because something exploded and stained it, right? So that's the difference between cosmetic or if it's indicative of a defect in whatever that issue is, right? So you see the difference between cosmetic and a structural defect. So that's the kind of thing you're looking at. Cosmetic is aesthetic imperfections and they don't affect the working condition of whatever the item is. And here are our examples. Pitted marcite, tears, worn spots, discoloration of floor covering. So if the carpet is worn someplace, too bad, that's cosmetic. We don't have to replace it. Wallpaper, window treatments, nail holes. You take all the pictures down, there are all these nail holes, cosmetic. We don't care. Seller is not responsible for that. Scrapes, scratches, dents, chips and caulking, ceilings, walls, floors, all on and on, okay? So it tells us those are cosmetic. Seller is not responsible to do it. Cracked roof tiles, curling or worn shingles, or limited roof life is not a defect. So if the report comes back and says, oh, the roof is shot, but doesn't matter if it's limited life. The air conditioner is old, too bad. It's still working. Okay, that's all we care about. So you see how these could come into play, right? The buyer sends the Christmas tree wish list back with all of this stuff. And then the seller's agent, you as the listing agent, and the seller go through those items in view of these definitions. And then you decide what is a general repair item and what is merely cosmetic. So that's where the work comes in under the standard contract. That's where the negotiation comes in. Does that make sense to everybody? Okay, so working condition means, and I'm at line 284, it's operating in the manner in which it was designed to operate. So air conditioner's old, but it still works great. That's all we care about. It's in working condition. Okay. Make sense? All right. So what are the repairs? We just talked about it. Seller is only obligated to make those general repairs that are necessary to bring it up to that condition that we just defined in the previous paragraph. So here's how it works. Remember I said 10 days. So 15-day inspection period, boom, buyer sends the list of items. And if seller requests it, then the buyer will send that portion of the inspection report that supports that item that's on the list, right? That makes sense. So the seller can verify, yeah, this is really what the inspection report said. So after seller gets that, seller has 10 days to two options. First is get cost estimates for all those repairs. So you go through the list, you eliminate the ones that are cosmetic, you're left with whatever is left, and then the seller gets repairs for or estimates for all those repairs. Or maybe seller goes, well, that's nonsense. I'm going to get my own report, and seller can do that. Well, if the seller thinks that the buyer's report is nonsense and the seller sends the seller's own report, what do you think the buyer's going to think? That's nonsense, right? So if that happens and the buyer rejects the seller's report, then the contract requires them to mutually agree on a third inspection, and they will be bound by whatever that finds. So let's go back to seller gets the estimates for the costs of the repairs. If the cost of repairs is less than or equal to the amount that we put in paragraph 9A, so super important, right, to make those numbers make sense, less than or equal to, the seller does it all. If it's more than, then here's what happens. And I'm at line 302. Seller can say, I'm just going to pay it all. Probably not going to happen, right? Or the buyer can say, a la carte, I'll take this and this and this and this up to the repair limit, and then I'll take the rest as is. That could happen, right? They have 5 days after the seller gives the buyer the cost estimates. 5 days to consider what they're going to do. If neither of them gives notice to the other one, then either of them can terminate the contract. One of the rare instances when the seller has the option to terminate. So let's think about the time frames. 15 days in our inspection period, plus 10 days for the seller to get the cost estimate. So we're at day 25. Then 5 days for them to consider what they're going to do about the cost estimates. So we're at day 30. There's no way that a 30-day inspection, a 30-day close can work for a standard contract. Does everybody see that? You just can't make it happen in that amount of time, because we haven't even gotten to the point where we start repairs. We've only gotten to the point where we're deciding what we're going to repair. So you need much more time in a standard contract. Always keep that in mind. If people are looking for a quick close, a standard contract is probably not going to help them. All right, so that's our general repair items. Any questions about that? All good? Okay, let's move on to C, wood destroying organism inspection and repair. So,
hey, Sallie, I'm sorry to interrupt, but there's a question on chat. If there is financing, what about the age of roof and insurance? FHA also at one time called torn carpet and made repair mandatory to get financing.
yeah, so that's a different issue, and that would probably be addressed, because when you use the FHA VA addendum, there's a blank in there where you put a repair amount for the seller, and it says in addition to the repair limits in paragraph 12. So that would be a separate issue, and because that's a special loan program. But if FHA VA is not an issue and it's not a lender issue, then this is what the contract says. Does that answer the question? Does that make sense?
Yeah, okay. How do you know?
How do you know what?
How do you know going forward? And when you're first writing your contract, how do you know there's not wood destroying organisms? How do you know? I mean, I've looked into.
Yeah, you don't. And that's an excellent question. And that's what I always tell people, that the paragraph 9A presupposes that you have some pre-existing knowledge about what the condition might be. Otherwise, how can you make those numbers make sense, right? I certainly couldn't. And this is before we've had inspections. We just have to kind of guess at numbers that might make sense. So it's tough. It's tough. Yeah. And as an agent working with a buyer, if they ask you, well, what do you think? I don't think. I don't think. These numbers are up to you, whatever you think makes sense, right? Because what if you tell them, oh, I think it's good with $1,000, and then it comes back it's 5,000.
Correct.
Yeah.
And we're talking about in this market. And so if I'm a buyer's agent, the seller wants this type of a contract, I'm not going to put anything down if I want to win the bid, because
exactly.
So, yeah. I mean, it's all a moot point, sort of, to me.
It really is.
And I just kind of like, I'm sorry.
I know.
making me,
And I mean, you can put 0, but you still have to go through all of the motions of everything that happens here, right? To get to that point.
well, if
And
you're
and
zero,
if you put 0, then you've effectively turned it into an as-is contract because you're giving the buyer an easy out. And I think listing agents who say standard contract only, they probably don't fully understand how it works. So
no, if you get,
yeah.
I see it as if you put 0, what your buyer is saying, I'm buying this no matter what's wrong with it, because they're obligated to buy.
No, not really, because remember, as we just walked through this process, if the buyer can still get a list of repairs and the seller still has to get an estimate of the cost, well, of course, the cost is going to be more than 0, which means that either the seller says I'll pay it or the buyer says I'm terminating.
Okay, so just like a regular contract,
Yeah.
I can request whatever, and it's
Uh-huh.
not time to negotiate again as to
Yeah.
what happened. Okay, I
Yeah.
got it. Oh, good.
Yeah, so again, that's why I'm kind of speculating that I think listing agents who say standard contract only don't really fully understand how it should work.
Okay. Well,
I mean, does everybody else see that? And after what we just talked about with the general repair limits,
I do.
you know, if the repair limit in paragraph 9A is 0 and the repair comes back at $1, boom, I can get out. Unless the seller says I'll pay it, right?
Okay,
Yeah.
I get it. I get what that says now. Thank you.
Yeah.
so much. I appreciate
Sure.
it. Glad I asked the question. I'm sorry.
Yeah, no, I'm glad you did. That was good. Thank you. Okay, so paragraph C, we're doing WDOs. It says the property may be inspected by a Florida licensed pest control business. Again, we go back to the licensing, right? They must be licensed to look at the existence of past or present. So past or present infestation and damage. So we're looking for both. Is there evidence of an infestation? Is there evidence of damage? Within the inspection period, buyer is going to send the inspection report to the seller if there is any evidence of infestation or damage. Okay, and then we define WDO. Now here's what happens. So let's say the report shows some infestation or damage. The first one is if, and this is at line 316, if seller previously treated the property for that type of WDO that the buyer's inspection report found, right? Then the seller doesn't have to retreat the property if there is no visible live infestation. It's just evidence of a past infestation and the seller treated it. That's it. Seller doesn't have to do anything except transfer to the buyer a current full treatment warranty for that type of WDO. And that's done at seller's cost. Okay, so let's assume that it wasn't that type that had already been treated. So seller gets the report, same time frames, 10 days, seller goes and gets estimates for the treatment plan, right? And then seller's going to have all that stuff done if the estimate comes in at or less than the amount that we put in paragraph 9A. Now, let's say that it's more than paragraph 9A, which could easily happen, right?
Right.
Then 5 days, just like with the general repair items, 5 days, buyer can give a notice back to the seller to pay the excess, meaning the buyer will pay the excess, or saying, I'll, do this, and the rest of it, I'll take it as is. So same concept, a la carte, I'll take this and this and this up to the repair limit. Everything else, I'm going to take it as is. We put that on the buyer. So you see, it's different from the general. In the general, we gave the seller the option of saying, I'll pay it all. In this one, the only choice is the buyers, because the thinking, according to the contract preparation manual, is possible stigma associated with a property that has WDO damage or infestation. Makes sense, right? So if the buyer doesn't give that notice to the seller, then either party can terminate the contract. So again, rare instance where the seller could terminate. So imagine, same scenario like we just discussed, you put 0 as the repair limit in paragraph 9A, it comes back at $500, buyer can terminate. So sounds to me like it's an as-is contract when you put 0. And I hear a lot of agents do that because they want to make it more attractive to the seller. But ultimately, the buyer can get out of it very easily if they wanted to. So I don't think that accomplishes what the listing agents want to accomplish. Okay, and in each instance, if the parties give notice to terminate the contract, then the buyer gets the escrow back. Any questions about WDO? Okay, our next category is permits. And remember, this covers everything: open, expired, and unpermitted work. So what this says is buyer can have an inspection and examination of the records and documents to determine all this. And this is not necessarily something that is automatically included as part of your title work. And if it is, sometimes they're not going to get it to you within the inspection period. So there are services, companies that you can engage, the buyer can engage to get this report so that you make sure you get it within the inspection period. Because remember, if we don't give the notices as required before the end of the inspection period, then the buyer waives the right to have the seller make all of these repairs and take care of all these issues. So it's important to watch the dates. So if buyer finds anything, then buyer's going to give the notice to the seller, just like in all the others, right? And if there's anything that hasn't been closed, or if there's anything that is not permitted, then the seller is going to give the buyer copies of all the plans and everything associated with whatever that improvement is. So here's what happens. Buyer gives the notice before the end of the inspection period. Seller has 10 days to get estimates of the cost to take care of all these permit items. And it has to be appropriately licensed person for all of the repairs. So let's say that there's something with the roof, roofing contractor, there's something with the plumber, there's something with the power, the breaker box, electrician. So there could be multiple licensed individuals who are involved in all of this permitting stuff, right? So you have to get all of those estimates from those kinds of people and give a copy to the buyer. Then it says no later than 5 days prior to closing, seller has to expend funds up to the permit limit to have all of these things taken care of. And before closing, seller is going to provide documentation to the buyer to prove that everything has been taken care of. Well, I've heard that there are backlogs from the counties and cities sending people out to inspect and close out permits and all that kind of stuff because things are crazy, right? So it says that if we can't do the final inspection due to delays by the government, then we're going to extend closing for up to 10 days to get all of that stuff. If we're still not able to get it within the 10 days, then either party can terminate the contract. Of course, they could also renegotiate and agree to extend it again, right? It's not like they have to. They just have that option after 10 days. And then the buyer would get the escrow back. Make sense? Okay, just like with all the others, imagine that the cost to address all the permit issues is more than the amount in paragraph 9A. Then, within 5 days after receipt of the cost, here are our options. Seller can say, I'll pay it all. Not likely. Or the buyer can say, I'll take it as is and just give me a credit at closing for the amount in paragraph 9A, right? If neither of them gives that notice to the other, then either of them can terminate the contract. So in all of these instances, we are potentially 30 days into the transaction and somebody could terminate. So very important to let everybody know, just because it's a standard contract, it still could be terminated, right? And you want to track all those dates. Paragraph F, this is interesting. Any questions before I move on to paragraph F? Okay, so repair standards, assignment of repair and treatment contracts and warranties. So remember, we have to have all of our people who are licensed to do the inspections and to make the repairs. Here it says it, all repairs and replacements completed in a good and workmanlike manner. So those are kind of like term of art in the legal world, good and workmanlike manner. So it can't be sloppy. It can't be, you know, I'm going to use, like one seller did, I'm going to use toothpaste instead of caulking. That didn't work out so well, right? So it has to be done in a good and workmanlike manner by appropriately licensed people, and the materials or items of quality, value, capacity, and performance comparable to or better than what we have. So we have a big air conditioning unit that needs to be replaced, and the seller has to have the same capacity or better. They can't come in and put a smaller unit, right? Can't do it. Or we have, you know, really expensive, high-end, I don't know, faucet, you know, and the faucet's not working, so it has to be replaced. They can't just put a cheap faucet. It has to be the same quality. Same with the tile. If we have very expensive tile, they can't put something that's cheaper. If it's quartz, they can't come in with Formica on the countertops, right? Those kinds of things. So it has to be comparable to or better than we had at the effective date. And then it says, except as in paragraph 12C, and that's our WDO, that was when the seller was going to transfer the treatment plan and warranty plan for WDO items at seller's expense, right? Except for that, then the buyer can ask the seller to transfer all repair, treatment, maintenance contracts, and warranties, but it is at buyer's expense. So that's the difference between just a general treatment plan, warranty, whatever, versus the WDO that we talked about in paragraph 12C. Questions about that? Okay, we're moving on. Now, everything is the same. Everything is the same. Paragraph 18, everything is the same. Our next major difference is at paragraph 19. So let me show you the as-is contract at paragraph 19. Okay, here we go. These are our addenda, and we've talked about this before. I just like to make sure everybody understands. It says the following additional terms are included in the attached addenda or riders and incorporated into the contract. Again, magic language, incorporating language, so that anything that's checked is fully incorporated into the contract. And we have 3 columns. We start at A. This is our first column on the left, our middle column, and our column on the right. So column on the left, all good. Middle column, K and L, it says reserved, right? This is the as-is contract. Reserved means you can't ever use it with this contract. So K and L never used with the as-is contract. And you may remember this from the addenda class. And here's why. This is the standard contract, and look in the middle column, K and L are suddenly there, right? Which means we can use them with the standard contract. And here's why it would never make sense to use them with the as-is, because K is the as-is addendum. it turns the standard contract into an as-is contract. It goes through all of these paragraphs we've just been talking about, and it modifies them. It'll say, you know, paragraph 9A, blah, 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 is deleted. Paragraph 11, blah, 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 is deleted. Paragraph 12 is deleted. So it goes through every single paragraph and it deletes the standard language to fully turn it into an as-is contract. And that's why you would never use it with an as-is contract, because it's already as is. And yet, you've probably heard me say, I have seen agents use the as-is contract and the as-is addendum together. Never do that. The next one, L, is the right to inspect / cancel. What this does is turn the standard contract into a hybrid between the as-is and the standard. So what it does is it says during the inspection period, the buyer has the sole discretion to terminate the contract. That means any reason, no reason at all. So it's exactly like the as-is contract. If the buyer doesn't terminate within the inspection period, then all of these repair provisions kick in paragraph 9A and paragraph 12. So the seller then is responsible to make the repairs up to the limits in paragraph 9A. So it's a hybrid. So it could be like the best of everything for a buyer particularly, right? And I was doing a class on this recently, and agents said that they have successfully used this when the seller says, I want the standard contract. They put the right to inspect and cancel addendum on it, and it goes through. And I don't mean to make this sound like you're getting one over on the listing agent, but I think a lot of agents probably don't understand how that addendum works. Not that it's really disadvantaging the seller, right? Nonetheless, it clearly could work to the advantage of the buyer. Any questions about the addenda or the additional terms? Okay. Paragraph 20, additional terms. I know we've talked about this before. I just want to reiterate, take care in what you put in additional terms. It's really for overflow. If you have too much legal description for those lines up there in paragraph 1, if you have too much personal property in paragraph 1, if you have too much excluded property, put it here in the additional terms. Paragraph 9, when we talk about other costs to be paid by the seller or the buyer, put it here also. Or you could say at that line, because it's a pretty little line, you could say, see additional terms, paragraph 20. So that's the kind of stuff that you want to use this for. Take care that you don't start writing new terms of the contract. An agent showed me something recently and it was like, oh my gosh, you've just changed everything, right? By writing in there, and you change the rights and responsibilities of the parties, which means they really shouldn't be signing anything unless they go talk to the lawyers, and agents shouldn't be writing that because it's unauthorized practice of law. Another tip is if there's an addendum for it, use the addendum. Don't make up your own language. You've heard me say this before. Too often I've seen agents write, contract is contingent on review by the seller's lawyer or the buyer's lawyer. And we have an addendum that says approval by the lawyer. Review does not mean approve. Words matter. We know that, right? Review does not mean approve. So approve means if I don't like it, then the buyer or the seller can get out. Review just means I get to read it. Doesn't matter what I think about it. The parties are still bound by the contract. All right, moving on. Everything is the same. I just want to point this out because it's important to point it out. When you talk to the buyer and the seller about the contract, because they should both be familiar with the form of the contract before you get into a contract, start on this last page where it says at line 673, this is intended to be a legally binding contract. If not fully understood, seek the advice of an attorney prior to signing. That's what they should do, right? If they have questions, you can tell them what it says but you can't tell them what it means. And that's the distinction. If they have questions about what it means, then they should talk to a lawyer, their own lawyer. And then at line 679, an asterisk means that there's a blank and it is to be completed. So a tip, I always try to enforce this with people. If there's a blank line, and even if you're using the default provision, put the default provision in. Don't leave anything blank. If it doesn't apply, put NA, because it's so easy and it has happened frequently. And I don't mean to suggest that people are not honest. However, it has happened that the other agent will put something in a line that was left blank, and suddenly the other party is obligated for something that they didn't fully agree to because it wasn't pointed out to them. It's so easy to overlook something that was left blank, right? All right, I'm going to stop my share. And are there any questions? I'm going to look at the chat now that I can look at the chat. Okay, we already talked about that. All right, any questions? We have a few minutes. It can be about this, it can be about another contract, an addendum, an issue, whatever.
I have a quick question. Can you hear me?
Yes, a little bit.
Under the addenda checklist, what is a kick-out clause?
Oh, okay, good question. So the kick-out clause is, and some of you may have heard this, I call this the addendum. I came to the party with you, but I might be leaving with somebody else. And so what it says is, and this would be something that the seller would use. The seller says to the buyer, look, I'm going to accept your offer, but if something better comes along, I reserve the option to kick you out. And so seller gets a backup offer that they like better. They come to the buyer and they say, you need to put additional funds into escrow, and you need to waive the contingency for the sale of your property, and you need to waive the financing contingency if those two things are contingencies. And if you don't, then you're out of here, which means that the seller then is free to go with the backup offer. So they kick the buyer out of the transaction and get into a transaction with somebody that they like better.
Okay, thank you.
Yes, you're welcome. It's harsh, right? Because if you have a contingency to sell your property and or a contingency for financing,
right,
they're there for a reason. And how many people would be in a position to waive those contingencies? Not many, right? Yeah. Yes.
May I
Yes.
talk? Hi,
Yes.
Sally, with our crazy market, seen it before, do you have anything, an addenda or language that can be used from a seller's perspective to say, give them 5-10 days to find a new property before agreeing to a contract with a buyer?
So almost like it's a contingency for the purchase of the seller's new property.
Absolutely. We
Yeah.
don't want them homeless. So how do we protect them when we're
Right.
finding
And
a seller?
we don't have anything that we've standardized for that. And we have gotten quite a few requests. So I'm going to talk with Murray about it again, because
Sure.
if you're on the forum, we recently came up with that language about the appraisal because it was such a recurring issue. So I'll check with him and see if we can come up with something for you. Can't find a pen, of course. Okay. I'm going to type it in the chat and then I'll save the chat.
Right. Thank you.
Hey, Sally, can you put the as is and the standard in the chat so that I can print those
Yes.
up and look at them?
Yes, I will.
Thank you.
Yes, you're welcome.
Sallie, one more question. As a new agent, I can assume after listening to what you said in this class as far as the inspections and everything, with the crazy market that's going on right now, can I assume that there's a lot more as-is contracts and a lot less inspections going on right now?
Yeah, yeah, I'm hearing a lot of agents say that they have waived inspections. I mean, not that it's a contingency anyway, and that's kind of a misstated question that I get from people a lot. How do we waive the inspection contingency? There is no inspection contingency. You just either do it or you don't, right? And the inspection period expires naturally on its own. So yeah, a lot of people are putting 0 days as an inspection period.
Okay.
And I'm looking in here and it's not giving me the option to add a file from my device. It's only like Google Drive and stuff. So if you don't mind, put your email in the chat and I will email them to you as soon as class is done.
Sallie,
Yes.
I have 2 questions. One, can you go over again what you said as far as the additional terms you said to put in, like if you're leaving property or other costs to be paid? What were the other items you suggested go in that spot?
Yeah, so overflow for the legal description, overflow for that paragraph 1D where it says personal property that is included in the transaction. Because there are just a couple of lines. If there's more than will fit in that line. Paragraph 1E is property that is excluded from the transaction. So maybe there's too much to put there. You could use paragraph 20 as overflow for that. Paragraph 9A and B, because we talk about the closing costs to be paid by seller and buyer. And then there's a line on there that says other. If we're asking for seller to pay closing costs, you could put that on the other line. Well, there's not a lot of room there. So you might want to just say, see paragraph 20. And then we have a similar line for the buyer in paragraph 9B, where we're asking them to pay other costs. Like maybe we're asking them to pay the documentary stamp taxes on the deed for the seller rather than the seller pays it, right? So we could put at other, see paragraph 20, and then in paragraph 20, we can write that out.
Okay, thank you. And then the last one is, you mentioned that we can explain to them, what's in the contract. No, you can tell them what it says, but you cannot tell them what it means. And that's something I've been wondering. How do you, when they ask you, oh, well, what does this mean?
Yeah.
How do you explain it to them without crossing that line?
Yeah.
You know what I mean?
Yeah. So if they ask you what it means, just say, look, I can't tell you what it means. All I can tell you is what it says. And here's what it says. And, just show them the contract. Here's what it says. And if they still have questions about what it means, then they could talk to a lawyer. So for example, in paragraphs 15 and 16, we talk about default and what remedies are available on default, right? And so let's say if all it says is if the buyer fails to perform, then the seller can do this. Well, maybe the buyer didn't get the escrow in on time. And so the seller could say, well, is that a default? Well, I don't know. I can't tell you that. All I can tell you is if it is a default, here's what the contract says that you can do.
Okay.
Does that help to clarify some of the distinction?
Yeah, a little bit. The other thing is sort of along those lines though, like when they say, okay, what should I do? What should we do? If there's an option, right? What should we do? Well, what is and what is not legal advice? Right?
Yeah. So, and that's going to vary so much based on whatever the circumstance is, right? And so I would always say, well, here's what the contract says you can do. It's up to you to decide if this is a situation where that comes into play, like, buyer was late with escrow. Here's what you can do. It's up to you to decide what you want to do. and which option best meets your goals for this transaction. So as much as you can, just put it back on them.
Okay, thank you.
Yes, you're welcome. Okay, any other questions?
Well, thank you.
Awesome. Well, I appreciate that you all came here today. It's a pretty day, at least looking out my window here, and I'm sure you have lots of other things that you can and should and would rather be doing. But I appreciate that you're here. So thank you. And if you have any questions later on, just let me know. You can call me or email me.
Thanks, Sallie.
Thank you, Sally.
Okay, thank you.
Time.
Bye, everybody.
Bye.